Tim Blankenship here with divorce661.com, and we are back with another live broadcast, live stream here where we're going over today's issues are issues with true default divorce cases. We're also going to be answering your questions that you may have for us. We're trying to do this as a kind of just a help flow to people maybe trying to do their own divorces, trying to get through their divorce on their own. We're answering your questions about some of the divorce paperwork, maybe places you got stuck, maybe you have your judgment rejected, things of like that. We'd be happy to answer. Can't do your entire divorce through questions through the live stream, but if you have a simple question about a checkbox or a particular form, we'll be happy to go over that with you. But today's episode is going to be about true default divorce cases and the issues that people have when they try and do a true default divorce. What that means is a default with no agreement. We get lots of rejected items coming in, clients hiring us to help them with their divorce case. And many times it's because they're trying to do a true default divorce. All that really means is that there is no agreement, whether that's because the other party is not involved or intentionally it doesn't want to be involved. Or in many cases, I will ask when people say, "Oh, I'm trying to get through the divorce process and we're in agreement, but my spouse doesn't want to participate for one reason or another." Sometimes they think they have to file a response, and so they don't want to pay that secondary fee. But that's not the case. It's the most difficult process to get your divorce done by trying to do a true default divorce with no agreement. And there's reasons for that. And I want to go over the different reasons that this comes up. I want to talk about the issues with true default cases as it pertains to property division, as it pertains to spousal support issues, and as it pertains to children. I always tell folks, do a true default case as a last resort. That's the only reason it's there, is to get through the divorce process if your spouse will not participate. When I have these calls with clients having difficulty getting their true default cases, the first question I ask them is, will your spouse participate? And most of the time, 99% of the time, the answer is yes, my spouse will participate, but they either didn't want to bother them or they thought it would be easy getting through the process. I'm also going to be talking about a couple of cases we took on this week that were done by attorneys where they were amicable, but one spouse got an attorney to process their paperwork, not a problem, but they actually showed as representing them on the court record, which means they're not going to help the other spouse with their paperwork. And so in all of these cases that were done by attorneys that we had to take over and finalize because they could not get them through the court. So that's how tricky a default divorce is, a true default divorce is. It's so tricky that this week we took over 3 cases where these attorneys, 3 different attorneys, were trying to finalize a default divorce case. And there was, on one case, 5 rejections so far with the judgment, to where the court said, hey, you need to set this matter for hearing because we need to see what's going on. So if an attorney is having trouble with the true default case, then you know that what I'm telling you is to treat it as a last resort. We're also answering your questions today. So those of you that are joining us, feel free to ask questions. We're not giving any legal advice, but if you have questions about the divorce process, the paperwork, maybe you're trying to do your own divorce, you're having rejections and so forth, let us know in the comments and I will try and check that and we'll answer those questions at the end. But today we're talking about true default issues when you're trying to file your judgment and having them rejected. So true defaults, they are highly technical. Why is that? Because when you file a petition for divorce, in that petition, you're going to make certain requests for alimony, whether you want it or not, reserved or terminated. If there's kids, you're going to mark down custody and how you want that to be applied. If you have property, assets, debts that you need to divide, you're going to list how you want to divide that. And it's highly technical on a true default case because let's assume you know your spouse isn't going to participate. When we have clients say, I know my spouse won't cooperate, and there's assets and debts, we have to file the petition in a specific way. You have to detail, and if you've watched my videos before, I tell you, do not file these property declarations with your petition. But in a true default case, if you know going in that's how it's going to be, then you have to file those property declarations because you have to spell out and list out the asset or the debt, the value, and then you have to show it being divided 50-50. And that's one of the challenges we're talking about when it comes to true default cases. Even if you have an agreement that, but they're not going to participate, the court will not, because there is no agreement, allow you to divide your property anything other than uh, 50-50. And I'm going to talk about a case we had several years ago where this did not work out for the petitioner. Excuse me, not that they got taken advantage of, it's just that the spouse said they could keep all the assets, but the court obviously did not allow that through a true default, no agreement type case. So so we're talking about the petition. If you know it's going to be a true default, you have to file a specific way. And once you do that, you cannot change anything. So let's say you prepare the petition and you say these assets are going to be divided equally. When you get to the judgment, you have to spell that out exactly the same way. You can't then add an asset. Let's say you forgot an asset on your petition. You can't add an asset. You can't change an asset. You can't change the division of it. It has to be spelled out exactly as the petition is. And this also causes other issues as it relates to spouse support, and literally everything that you request in the petition. If you have any changes, you need to start over, refile and amend your petition, reattach the property declarations, and resubmit your petition and reserve it as well. You're basically starting from scratch. So let's dig into these issues. I'm going to talk about property division first, spouse support issues, and then child support issues when it comes to doing a true default case. So the property must be divided equally. Let's say you have your spouse just doesn't want to participate for whatever reason. Maybe they think they have to file a response and don't want to pay the filing fee, which is not the case. There's a better way of doing that. But let's say that your spouse says, hey, you can keep these assets, I'll keep those assets, and the property division isn't going to be equal. You cannot do that on a true default case with no agreement being submitted to the court unless your spouse actually signs a settlement agreement stating such. That's why we say it's always treated as a last resort when you're doing your divorce as a true default. There should be no other reason to do that. Don't do it because you think it's going to be easier. It's not. Don't do it because you think you don't want to bother your spouse. It's going to cause you problems. Many, not all, but many of our judgment rejects, when people call us, and like the previous cases I was talking about, attorneys, they were rejected because they were simple cases, no assets, no debts, or minimal assets, but because there was any asset at all, it was causing the judgment to be rejected. And these were cases being handled by attorneys. So I'm just looking at my notes here as far as what else I want to talk about. I said, if you have an agreement that both parties will sign, you can divide up the property any way you want. That is called a default with a written agreement. So a default with a written agreement is the same as a default without an agreement, except you have an agreement, obviously, but it's still a default is what I wanted to say. It's still a default in that a response was not filed. It doesn't mean you're defaulted, like you didn't participate, because we're doing this as a written agreement. Now, the difference between a default with written agreement and no agreement is you get to call the shots on how you want to divide up the assets and debts. And also, where with the true default cases where there's no agreement, where if you made a mistake on the petition, if on a default with agreement type case, that will supersede anything you put in the petition. So let's say in the petition you listed 3 or 4 assets, and then when it got time to do your settlement agreement, you're like, oh, we also have this asset and that asset. You can add, change, modify, divide up your assets and debts however you like. And this goes for everything as far as spouse support, custody. For instance, if you asked for spouse support in the petition, maybe, and then you guys later agreed that you didn't want it, that's totally fine. You don't have to amend your petition. You can just then agree that there will be no spouse support in the settlement agreement. So that's why it's so much easier to do a divorce with a written agreement. So I want to talk about a particular case and kind of give you an example of how this can really work out negatively if you do it as a true default. I'm just seeing if any comments are coming. If you guys do have questions about paperwork, divorce forms, so forth, have a judgment rejected, let me know. We'll try and answer those questions at the end. So we had a case 7 or 8 years ago where parties were in agreement, but the husband just didn't want to participate for whatever reason. And it happens once in a while. But they had a ton of assets, 401ks, pensions, a house. And we had already filed the petition because the assumption was they were amicable and cooperative. And then the husband decided not to participate. Well, when that happened, we cannot turn in a judgment and just have the spouse get all the assets, which is what the husband says, that, hey, you can have all the assets. I don't want anything of yours. And that would have given her a lion's share of assets and not have to divide them. We're talking in the millions of dollars. So when this happened, when he didn't participate, the court basically forced the wife to give him his community property share, because without an agreement to the contrary, you cannot split, you cannot divide your assets other than 50-50. So what we had to do in this particular case, even though the husband was verbally saying you can have it all, we had to amend the petition, treat it as a true default case, put all the assets of the other spouse. Then we had to refile the case, and we had to reserve it, and then we had to draft the judgment exactly as the petition was filed on a true default case. So it's definitely always better to have your case be a default with a written agreement. So now I want to talk about some spousal support issues that can happen on these true default cases. So there's some rules regarding spousal support as it relates to long-term marriages. If you've been married longer than 10 years, you cannot terminate the jurisdiction over spousal support, the court's jurisdiction over spousal support, on a true default case. California law says that the court will retain jurisdiction on any marriages longer than 10 years. So here are several issues that can come up with that. Let's say you're trying to file a default without a written agreement and you've been married longer than 10 years. And let's just talk about the spousal support issue. We're going to leave out the property issue since we already discussed that. So if on your petition you marked terminate the court's jurisdiction over petitioner and respondent, filed your petition, that's fine. That's going to go through just fine. They're not going to, the court's not reviewing anything yet. And let's say you do all the paperwork fine, and then you get to the judgment phase and you turn in your judgment as a default without an agreement. The court's going to reject your judgment because you marked terminate jurisdiction on your petition. And even though you matched that up on your judgment and marked terminate the court's jurisdiction, that goes against California law and they won't allow you to do that. So then what you would naturally do, right? Because they're not going to tell you how to fix this. What you would naturally do is you would say, okay, well, I'll just correct my judgment and I will mark reserved jurisdiction since that's what the court said is mandatory. So you redraft your judgment, you put reserved jurisdiction like the reject letter told you to do, you turn it in, and guess what? It gets rejected again. Now, here's why, because it no longer matches the petition. So if you do the petition wrong in any scale, whether it's property, assets, debts, kids, whatever it's related to, it will cause your judgment to reject if you change anything. So what does this person then have to do if they want to have their judgment approved? They have to amend their petition. They have to refile it, reserve it, wait again the 30 days because that sets aside the default. It's a whole nother story for that. Then you can turn in your judgment, but you have to basically start from scratch, go all the way back to where you started and refile. Now, one alternative you can do is if you don't want to amend the petition, well, in that particular case, you would have to amend the petition because there's no way you're going to get that default or that no spouse support request in a marriage of longer than 10 years without correcting that, because you can't fix it on just the judgment. You have to amend the petition altogether. Now, when this happens and people call me and they say, hey, Tim, my judgment's rejected on this particular issue, the spouse support, long-term marriage, they're saying I can't do it on default. So my question always is to all these clients is, will your spouse sign a settlement agreement? And usually the answer is yes. And so when they say that, all we have to do is we don't have to amend the petition. All we have to do is draft a settlement agreement and they sign the waiver language that indicates that spouse support will be waived. And that's the game changer, if you will, in getting these cases through the court. Like I said, the 3 cases we took over this week that had attorneys prior, they're all trying to push it through as a true default without an agreement. And there are simple cases, limited property, mostly debt, and 5 rejections from an attorney. And like I said in the beginning of this, if an attorney can't get a true default case through the court, you're going to have trouble getting it through the court. I saw that they're trying to set hearings. They're trying to get in with the court to explain, and they're just adding time, unnecessary billing. And there's an easy way to fix this. So the clients that hired us this week that had attorneys, we prepared a substitution of attorney form for them. The attorneys gladly signed it because they wanted to get out of this as well. They may not, they may be asking for more money from their client since they're billing on an hourly rate versus the flat fees that we charge. But we took them over and we've already completed all of those cases. The paperwork is done. They've already signed their documents. We're just waiting for a notary. Then we can e-file your case with the court and it's done. As a default with written agreement, we can fix anything. With a true default case, they are the most problematic cases to get through the court, and you want to treat that as a last resort. Okay, so I want to talk about issues with as regards to children and child support. And I just want to take a look at my notes here real quick to see where we're at. So with the child support and children involved in general, the first thing the court's going to want to know is, why is a parent being defaulted? Why are they not participating in the divorce case when there's children in custody and all that? And it does happen. We don't see it too often with our cases because we're taking, I should say, all at this point, amicable cases where the parties in agreement, but where cases where maybe one spouse drops out or for some reason doesn't participate at some point, we will have to deal with these issues. But again, let's say that you filed your petition for divorce and you have children, and on the request for parenting, you just put joint legal and joint physical, and you don't put anything else on there. And then let's say it turns into a default without an agreement. When you go to do your judgment, that's all you can say on your final judgment. You can't add anything. Same with that, the spousal and the property division. You cannot add anything to your settlement agreement. Well, it's not a settlement agreement because no one's signing it. It's just a judgment, but you can't change anything. So let's say you listed joint legal and physical custody for the children. When you submit your judgment, that's all. When you turn in that custody order, that's all it can say. You can't add anything to it. You can't add, father to have these days or times. You can't make any changes. Your custody order will literally say joint legal and joint physical. And that's fine. Most of our cases, because they're amicable, the clients are choosing just joint legal and physical. So that wouldn't be an issue. But the point of this being, if you did make an error on that, maybe you missed a checkbox, you didn't, or you marked by accident the other parties to have full custody or something like that, you can't change that on the judgment as a default without an agreement. Again, and this is why I keep harping on why you want to treat your case as a default with a written agreement or uncontested if you don't mind paying the filing fee, but I don't see why you'd want to do that. Do not do a default with a written agreement. It's going to set you up for failure in the process. And again, when people call us saying, hey, my judgment was rejected, and I look at their file, the first thing I can see is if there hasn't been any forms filed by the respondent, usually like the declaration regarding service of disclosure, which, by the way, you still, as the respondent, need to, even if you haven't responded and you're doing a default with a written agreement, you still need to do certain paperwork. You still have to do disclosures and some other things, not a big deal, but then you can then be part of the case. You don't have to respond. You don't have to pay the filing fee. And that's how we handle the majority of our cases. We do have parties that want to respond, and that's fine. We don't charge extra for that. If you want to file your response, there's nothing wrong. Doesn't mean you're fighting the divorce. Just means you officially appeared. It's not necessary if you're amicable and cooperative and we're handling your case as a neutral third party. But we just had someone the other day that yesterday, in fact, said, hey, I want to file a response. I don't want to default on my record. And it's not like it's something like that, but people sometimes just feel better to do the response, and that's not a problem. It doesn't mean you're fighting it. Sometimes it can actually make your divorce go faster as far as getting approved, because once the response is filed, you no longer have to wait the 30 days from the date of service to file your judgment. You can turn it in right away. So what we'll probably do with these clients, because they've already reached an agreement, is file the petition once it's signed, get a case number issued, avoid having anyone be served, because you can just file the response. That takes the place of the person needing to be served. That then automatically triggers a point where we could submit the judgment the very next day if we wanted to, if we had that ready and they had signed it and notarized it. So if you want to get them in faster, sometimes we've done that where parties want to get it submitted and get it reviewed, even though it doesn't speed up the 6 months. Some people want to just get that response in so we don't have to wait the 45 days. The alternative is what we normally do with our cases is we will file a petition. We will have the respondent sign what's called a notice of acknowledgement of receipt. Just it says, hey, yes, I understand a case has been filed and I received a copy, and we have that signed electronically. That's in lieu of being personally served, and that's the best way to do it if you're amicable. Then during the next couple of weeks or days, however long it takes the parties to get us their agreement, we'll finalize their paperwork. Usually that's done in a week or two, depending on how fast they got us the information. And then they're done. We have them sign, pre-sign everything. We post-date a couple things because certain things have to be dated in the future based off the date of service, which happens to be the request in or default form. So we'll predate those. And then we basically get it uploaded for the judgment to be filed, especially for LA County, where we can e-file the judgment, which is nice. We get it loaded into our system. We calendar it to when we can file it, but we do have to wait. What we do for safety is, so it's 40 days. Let me back up. It's 30 days by personal service, but we don't have our clients personally served. It's 40 days, 40 days by notice of acknowledgement. So we usually just wait 45 days. We calendar it for that date because it's still, we're getting your settlement agreement and your judgment filed within, say, 6 weeks of working with us. So we're well ahead of the 6 months. And we filed 2 cases yesterday, one with Central, one with Chatsworth. And when I say file cases, we filed the judgments. And this morning we already received them back approved. So LA County went from, I don't want to say the worst to work with, but they are definitely the best to work with as far as e-filing. And I talked about in that some other videos. If you're doing your own case, definitely look up the e-service providers. You get notification of it being accepted, you get notification of it being received. Whereas, just 8 months ago, we had to mail file these judgments with the court, and you got no indication that they've even received them. And then I shouldn't say many times, but often, I shouldn't say often, I would say occasionally they would lose the file. And even though we have evidence of it being mailed in, because we would use tracking, they would say it's missing or couldn't find it, and we'd have to turn the judgment in again. And it's funny because we would turn in the judgment again, and then that would get rejected because they would find the one they lost and say the judgment has already been submitted. So it was kind of crazy for the first 10 years of doing this, but the last 8 months working with LA County has been much better to deal with. So I'm just checking if there's any questions, those of you that are on live with me. And if you're watching this on the replay, feel free to, if you have questions, just go ahead and put that in the comments or the chat, wherever you're watching this on LinkedIn or YouTube or Facebook or whatnot. And I am trying to be good about getting in and answering the questions you guys have about the content that I'm giving you. So that's what we talked. True default cases, no agreement, avoid it like the plague. It's the last thing you want to do, last resort, as I tell you. Default with written agreement is the way to go. The cases we took over this week, we handled them in just a matter of days after having the attorney substitute out, as they were trying to push it through and having multiple rejects as a true default. So if they can't get it through, neither will you. Hopefully your spouses are will cooperate with you. That's the type of cases that we handle. And when that's the case, it becomes more procedural in nature than legal, if you will. You guys get to call the shots with our service. You make all the decisions. We file all the paperwork. You just give us the information and signatures, and we take care of the rest. It's a really good process when you're amicable. I think our clients are surprised, especially the ones today where their judgment was approved in a day. We started with them just 6 weeks ago, and their divorce case is complete, but their divorce won't be final until I think July 26th is the ones that came in today because of the 6-month cooling off period. So even though we can get everything done, which our clients highly appreciate, because they worked with us for, we worked for a week or two in the beginning, got everything done, signed. Behind the scenes, we're doing the processing and e-filing with the court. And then they, within 6 weeks, they're having their judgment approved. So they are done. They don't have to wait 6 months. They're not grinding through the divorce process for 6 months. They're not dealing with us for 6 months or their spouse for 6 months. They are literally done. The only thing pending is the actual date of dissolution of their marriage. So the clients that got their judgments today that have a July 26th finalization date, they have their judgment, their marital settlement agreement, everything they need as evidence of their divorce. Then once that date passes, now they're officially single people. All of the terms the judgment's already been entered by the court. The court has already signed it. All the orders or requests that you guys made are now court orders regarding custody and property division. All that stands immediately. The only thing that remains is the dissolution of the marriage, because technically, remember, that's that cooling off period. So technically, they could say we wanted to cancel the divorce before that July 26th date comes. It doesn't happen very often. We have had clients call us 2 weeks before the date, and they decided to reconcile, because I guess that could be considered one issue of us getting these cases done so quickly, is they're well done before the 6 months even gets there. At any point up to the 6 months, you can dismiss the case. However, it's more difficult once it's been entered by the court. So let's say we filed your divorce case and we're still within the process and you want to have it dismissed. You just sign a dismissal form. We file it. It's instantly dismissed and it goes away. Once the judgment has been entered, and like in these cases where it's July 26th is the final divorce date, now that the entry of judgment has occurred, it's been court ordered. The only way to set aside the judgment then is to file a motion with the court and go see the judge and explain to them, both of you, that, hey, we don't want the divorce to go through. Now, in an ideal world, that would be easy. We would file that motion, get you a court date, you show up. But when you're close to the end of the termination of your marriage date, and the hearings, like in LA County, for instance, and many courts, are taking 45 days to 2 months to get into court on these motions. Many times the divorce is finalized per the court order that you already have before you ever get into court. And even though those clients have gone in, we've done this maybe, I don't know, half dozen times in 10 years where we've sent them in. And they have, I'd say the other half of those clients, they win. They said, look, you went through the divorce process. It's already been entered by the court. I'm not, we're not going to dismiss a case that's already been filed. Just get remarried. So you want to be careful. You don't want to run that time out too close, especially if the judgment's already been entered. It's going to take time to get into court to have that dismissed. So just words of the wise there. I think that's all I had for you guys today. We're going to try and do these daily. We're now doing them at noon as opposed to 5 p.m., trying to catch people on their lunch hour, see how this turns out, answering questions. I'll chat here for a few more seconds if you guys want to get your questions in. We had a good session, I want to say last week, had a bunch of people asking questions, good questions talking about divorce judgments and things of that nature, and questions are having about the rejected judgments. And I think we corrected a couple things for people just doing this as a public service and to get some more content out on our social media platforms. So thanks for you guys who tuned in. You can always check our YouTube channel, Facebook, and just see, we try and at least a few hours out, get these planned live broadcasts out so you can get a notification. Especially on YouTube, you can get notified if you click the red bell. You'll get notified when we decide to go live and when we set these up. And we also have them on our website at divorce661.com under the live broadcast. I think it just says live, and on there it will show what live broadcasts are coming up, so you can kind of plan to watch that and get your questions answered or just learn more about our services. Again, thanks so much for tuning in with us today, and we'll see you tomorrow at noon.